Robert Silverstein. And then Tom Gertmenian. And then Sally Barngrove.
Thank you, Honorable Mayor and City Council. My name is Robert Silverstein with the Silverstein Law Firm in Pasadena. Let the record reflect that I did provide to you an additional letter. We've participated in this process for many months, and certainly I began in 2013 on behalf of Tom and Sally Gertmenian. I did provide to you an additional brief letter this evening, as well as an additional short email and photo from Mrs. Gertmenian, and let the record reflect that those should be part of the record now. What is before you is a dangerous proposition. As Councilman Madison asked, is there any other archery range where arrows impact private property? And the answer is no. There is not, to our knowledge, anything that is as inherently dangerous and in conflict in terms of a recreational use of an archery range and private property rights and the intersection with others who use this area, although there has not been, to our knowledge, death or injury. It is something that you have to anticipate with the increasing usage that you have heard about tonight, including from Mr. Spears. Mr. Spears correctly said and conceded, quote, participation is climbing. Yes, it is. It is expanding, and its interest and the excitement for archery is expanding. And nobody objects to that. What we object to is the failure on the part of staff to adequately analyze that in terms of, for example, CEQA. The main basis that you're not pursuing an environmental impact report is this alleged notion that there is little or no expansion of use. You have heard from the primary proponent of what is before you today that there will be dramatic expansion of use. These arrows that I'm holding up and let the record reflect, except for one of them that was found by Mr. Gertmenian on December 14th, about 10 feet from his property line embedded in a bush, all the others come from the property of Dennis Lowe, 2 doors away. These are all all arrows that have impacted his private property. This is not hypothetical. And what also is not hypothetical is the potential liability to the city from a safety standpoint, from a fiscal liability standpoint, and from a legal standpoint. What is before you today is irresponsible. I would respectfully submit that, last August there was a new case that came down called City of Pasadena versus Superior Court and Mercury Insurance. And this is an inverse condemnation case against the City of Pasadena, a recent Court of Appeal ruling. Article 1, Section 19 of the California Constitution says that the government cannot take or damage private property for a public use. Replete through your staff report materials are statements indicating and acknowledging that there will be errant arrows that will strike private property. This is an issue that you can't simply wish away, and that is why we urge you to take a step back, to not simply rush ahead into a folly of approving something that is so inherently dangerous for the city, fiscally, and in terms of the legalities of this. To the extent that the council does wish to move forward in some manner, at page 2 of my letter that was just provided to you, we do provide a short list of items that we think at a minimum have to be required. One of them is proper insurance, at least $10 million, not the $1 million that's suggested.
Mr. Silverstein, no prior arrangements were made for an extended presentation on your part. We normally try to accommodate that if we have the opportunity, but I regret to say that fairness to all the others requires me to ask you to bring your statement to a close.
Thank you. I will do so. The insurance requirement that has been proposed of $1 million is not adequate to protect the city, nor is it adequate to protect the private property owners. The private property owners insist on adequate insurance. What has been described in the staff report is totally vague and illusory. There's no dollar amount for the private property owners. It should be at least $10 million for the city and at least $10 million each for the private property owners as additional insureds. The city should also be requiring that the PRA indemnify the city for any damages that occur, for any liability, and for any lawsuits, whether it's from an
Sir,
injury.
I must ask you to bring your statement to a close.
I will finish with this sentence. Whether it's an injury, whether it's an inverse condemnation lawsuit, or whether it's a CEQA lawsuit, the PRA, with the benefits go the burdens. If there are going to be benefits, they need to be responsible for the burdens, and that includes indemnifying the city for any action that happens, not just liability, but defense costs. Thank you.
Mayor, can I just ask a question to follow up, not of Mr. Silverstein, but of our staff? You can be seated as far as
I
I'm
have a
concerned.
question.
Oh,
Before you leave the podium.
you want to go ahead then?
Sure. When
Okay.
did you say that those arrows were collected?
One of them was collected on December 14th, 2014. The other ones were collected by Dennis Lowe over a number, I believe they landed over a number of years. These are not all of the arrows, but he has contributed this many to us for demonstrative purposes. So I believe that in the last several years, he has kept up this collection.
Can you say why he has kept the collection and not reported it to police?
I believe there
whoever
was
collected them.
at least one report to the police, and the police did not follow up on it. But there was one report to the police for sure. And then with regard to the other arrows, I can't speak for Mr. Lowe, but I can tell you that these are real, that they impact. And if you were a homeowner there, you'd be darn concerned too about an errant arrow.
Thank you.
If I could, and I'll just start with that last point. Actually, the police did follow up on that. A Lieutenant Delgado did respond. He's retired now. I mean, part of the problem is trying to unravel, the last decade or two of events. And I don't know, Jackie, that we need to get bogged down in, were there arrows, weren't there, where were they? I believe there were. I've been up there. I think once Mr. Spears concedes that the technology now is capable of putting arrows into the yards, then the issue is sort of joined, and we don't really need to debate, when those arrows landed and where. It's a fact that they can. And my question of the city manager is, the insurance, I think, is a really valid point. Is $1 million, I don't think, is adequate for insuring against what might occur with bows and arrows. So I don't know if you gave any thought to a higher limit. And then my other question on that is, what's covered? It's interesting that there's this sort of debate tonight about exclusive use. And what I now can see is that PRA is saying it's not exclusive use. And what that means is a couple of things. One is they're trying to say, well, the rest of the Arroyo is still available. And we can talk about that maybe later. But the point about exclusive use is what they're saying is we want to come in, set up these targets, set up in the range, but then when we're not there, we're not responsible. And to me, that's a problem because there are going to be archers who are going to come down and use that equipment, use that range. And I think if we're going to give any sort of single-use entity, and I've got some issues, that I'll follow up with later on PRA, but I think that entity has to take on the responsibility for the conditions that they've created. I mean, it'd be like setting up a swimming pool down there. And you'd say, we're going to have the pool and we're going to have a lifeguard when our kids are there, but then we're going to walk away and the pool's going to be there. And if somebody comes along and drowns, well, that's just too bad. That's not on us. And I don't think we can let them get away with that. So have you given any thought to those issues, Michael, about the insurance and about what's covered?
We have given some thought to the amount of insurance and what's ultimately covered, and I'll defer to the city attorney for any specifics with that regard. Much of the coverage has been consistent with other similar type activities in the city, although you can probably argue whether there are other similar type activities in the city.
Yeah, I mean, I know this got a big chuckle the last time, and it probably will again tonight. Bows and arrows are inherently dangerous. They are lethal weapons, and I think one of the problems is tonight we have some of the best archers, sounds like in the world, that are here, and it's so amazing to listen to these young people and the other archers and all. Those aren't the people that I happen to be worried about so much. What I'm worried about is the people who say, hey, there's an archery range, let's have some beers and go down there and have some fun. And so is $1 million really for somebody shooting bows and arrows? That could cover the potential mishaps? I don't think so.
But that's what you just described, one of the key reasons why we're adding additional provisions. And this is a range that existed, so I would argue the issue of whether this is we're allowing archery to exist in the Lower Arroyo through the actions tonight. The archery has existed in the Lower Arroyo.
Well, no, but on that point, Michael, I respectfully disagree because if we don't allow it, it will not go forward.
Well, but you would have to actually take an action to prohibit it. Right now,
the action would be to not enter into an agreement.
That would just be entering into an agreement with the Roving Archers. It is still a designated archery range through our Lower Arroyo master plan. It just means you would not have an agreement with the PRA.
I think our code says that we have to take an action to allow archery or shooting of guns or certain types of activities.
You've already done that. That's the Lower Arroyo master plan.
Okay, well, fair enough. Then that really raises my concern about who's going to be responsible. Are you telling us the city is taking on this responsibility?
If you don't permit an agreement with the PRA, the absence of a responsible party and maintaining a archery range via the city of Pasadena's activities, then I would defer to the city attorney. But absent a third party that we're entering into agreement to maintain the archery range would mean that the city would be maintaining it.
Right, and I would not support that. I would not support the city just throwing some targets out there in a range and then stepping away. There has to be some regulation and some certification as you've provided. But I think it's got to be in for a penny, in for a pound. It can't be sort of, we'll be responsible when our people are there, but not the rest of the time. But let's just deal with the insurance issue. A wrongful death case involving almost anybody would be worth more than $1 million. So I just don't see how that's enough insurance.
Manager may have looked at this issue, and he's here, David Serrano. He may be better to speak to the level of coverage.
Thank you. We did analyze that and look at that, and our recommendation was to have limits not less than $1 million. So we didn't put an upper cap on it. We did indicate not less than, and that's the language we use in virtually every city contract is minimum limits or a floor, but nothing less or nothing below that.
Do we insure like the firing range that we operate for the police department? David?
That's a private range for use only by the city, so that would be covered under our self-insurance.
We do cover that under our property coverage, and we also cover that as part of our general liability program.
And what are the limits for that?
Well, for the property, we have over $1.3 billion in assets, so we cover up to that amount.
For the liability?
The liability, we cover up to $25 million for the city. You also have if I may, and Madam City Attorney, under the California Government Code, there are also some indemnity issues with respect to the city for hazardous recreational activities and other hazardous recreational activities that occur throughout the Arroyo area. Hiking and specifically archery is defined under the Government Code as a hazardous recreational activity. So there are some immunities built in there.
So that provides us with some immunity as the city?
Correct.
Yes.
For non-participants in the activity?
It indemnifies us against participants or other folks that maybe kind of joint use that area to some respect. But individually hiking and individually archery are considered hazardous recreational activities.
I happen to think that the indemnification is a good suggestion and that the coverage needs to be greater than $1 million.
Mr. Kennedy is waiting, if I'm correct, and then you, Mr. Gortho.
I think Steve's raises a legitimate point that you can't give short shrift to as it relates to liability coverage and the upper heights of it. This is a activity that does present some risk. And we need to take that risk very seriously in guarding against the possibility of someone being injured and having enough coverage to compensate someone if they are in fact injured. Having said that, driving a car is inherently dangerous, and the limits for under state law are less than the coverage that would be required by city government. In this instance, generally it's around $300,000 at the top end. I'd like to ask the speaker a question. It would be helpful if you could share with the council, in my view, even though my colleague somewhat disagrees, what is the length of time in which those arrows have been collected, and there was a representation made by a respected member of this community who has taken a very public position that there was on one particular resident's land up to 70 arrows over whatever period of time. And just so I can decipher and make some reasonable decisions based upon testimony from the podium and what has been provided, the voluminous record, can you share, as the attorney for the Gertmenians, and are you also representing Mr. Lowe as well?
No, I don't represent Mr. Lowe.
But you are representing the Gertmenians?
Correct.
Okay, can you share with the council what Councilwoman, the Vice Mayor, had asked related to those arrows and what time period in which they were collected?
To the best of my knowledge, as I said before, over the last several years, those were collected.
Thank you. You also represented that was just a sampling. To your knowledge, are there significantly more arrows than the ones presented here tonight? I asked that because, as I said, there was a representation that up to 70 arrows were found on one particular property.
To my knowledge, the answer is yes.
Okay. Since your answer is yes, it becomes very difficult for one council member to understand why the police chief would make a representation before this body that there had only been one complaint that he is aware of in reference to an errant arrow being reported to the police department.
Your question is?
No, it's just a statement. A recognition about the credulity of your statements, that's all.
Thank you, Councilmember Kennedy. I believe that the arrows which have been found on various parts of the property. So there are hillsides, there are roofs. I'm informed that arrows have struck or landed in a pool. Whether the one arrow that we're aware of that resulted in a police report came near to killing someone, maybe that's what triggered the report, whereas the ones that impacted the hillside weren't considered to be as imminent of a threat. However, I will emphasize that under constitutional law, each of us as property owners has an unimpaired and exclusive right to possess all of our property. So let's say that 90% of these arrows hit a roof. We're not going to be up on a roof, but there's no business for it hitting a roof. And let's say they hit a landscaped area that maybe only occasionally you'll use. It's still your private property and it's not proper.
I would just say that I appreciate your response. Thank you.
Let's then turn to Mr. Tom Gertmenian, and afterwards Sally Barngrove.
My name's Tom Gertmenian, and I'm the property owner on San Rafael, and my property goes all the way to the bottom of the Arroyo, and it had 2 targets inside my boundary, which were numbers 14 and 15. I'm here because the staff, the city staff is recommending what I believe is an inverse condemnation of my property. And that's kind of a violation of my rights. I am prevented from going on to parts of my property when the arrows are flying on particularly the weekends, Saturday and Sunday mornings. And I would like to be able to go to my property whenever I choose, or otherwise have an agreement that I stay away at certain times as long as I have freedom to go there at other times. The recommendation by the staff is giving exclusive right to the archery range for an immense piece of property, much of which goes unused for extended long periods of time. And this is an area which should be open to others when the archers aren't there. And they're generally shy away, or sometimes they walk across the barrier and risk it anyway. But it's a closure that is beyond reasonability, I think.
Thank you, Tom.
Am I done?
Your time has expired.
Oh, I'm sorry. Well, I would like to just end with, I'm not against archery in the Arroyo. I mean, to see these kids up here, I shot arrows down there. My kids shot arrows down there. I want to see other kids shoot arrows down there. But I think everybody should be able to do that. It's great. But I don't think we should close the whole area off to everybody when it's not in use by anybody. And that just doesn't make sense to me.
Thank you very much. Welcome.
Thank you. My name is Sally Barngrove, and I've lived in Pasadena since 1968. And I currently live on the west bank of the Lower Arroyo, just south of the Colorado Street Bridge. Our property, along with several of our neighbors, extends down to the flat area of the Lower Arroyo Park and currently serves as a backstop for the roving archery range. Those arrows that miss the targets, and many of them do, land in our yard. We find that the use of the range has intensified in recent years. There are more archers, skilled and unskilled, shooting at the targets with more powerful weapons at any time of day and night free of charge. Today, our grandchildren cannot use our hillside for play because of the danger posed by the potential of flying arrows. A public shooting range that relies on the goodwill of property owners in a residential neighborhood for its operation should not exist as it currently does. We want to be able to use our property safely. And not only us, but many people want to enjoy the natural area that is the Arroyo. Dog walkers, bird watchers, school children, field trips, plein air artists, joggers, horseback riders, et cetera, et cetera. And we want the extensive southern portion of the roving archery range open for the enjoyment of everyone and not fenced off for the exclusive use of a few. Thank you.
Thank you.